It's all about bail when it comes to the now infamous Alexander brothers. Will the prominent trio accused of sex trafficking and sexually assaulting women for years be granted pretrial release? We're going to break down the arguments from both sides, including the latest points from prosecutors in a filing that reveals so much about the case. Welcome to SIDEBAR, presented by Law&Crime. I'm Jesse Weber. Our coverage continues surrounding the Alexander brothers, Alon, Oren, and Tal, these wealthy and influential figures in the real estate and private security industries who are now facing some very serious charges, sex crimes charges at both a federal and state level. And now, one of the latest filings from prosecutors, federal prosecutors to be more specific, this letter to New York District Court Judge Valerie E. Caproni not only provides a great snapshot of the federal case, the potential evidence, the charges, but it lays out a comprehensive argument for why these alleged sex traffickers should not be granted bail, not be granted pretrial release. So if you're not totally familiar with this case that has been making headlines for the past month or so, the filing we're about to break down is a really good summation of what has happened and what we're talking about. So what are we talking about? Well, first, the federal case. What are the federal charges? Well, we have these three brothers that have been charged with participating in a sex trafficking conspiracy from at least 2010 through at least 2021. And furthermore, Tal has been charged with sex trafficking of someone identified as victim 1 through means of force, fraud, and coercion back in 2011. So that's another count in this indictment. But the third count, Tal is also charged alongside his brothers Oren and Alon with sex trafficking of another alleged victim, identified as victim 2 by force, fraud, or coercion. And this concerns back to events in 2016. Now, as described in the indictment, it reads, the defendants worked together and with others to repeatedly and violently drug, sexually assault, and rape dozens of victims, and that they, quote, arranged for these sexual assaults using the promise of luxury experiences, travel, and accommodations to lure and entice women to locations where they were then forcibly raped or sexually assaulted, and that they would often drug the alleged victims too. So when we're talking sex trafficking, it's basically using illegal means and transporting or recruiting or harboring or enticing women here for the purposes of commercial sex acts, meaning sex acts that are done in exchange for something of value. Doesn't always have to be money, could be attending events, could be travel, could be gifts, could be reputational benefits, something like that, financial benefits. Now, violence, deception, drugging, those can be key components of the sexual events as well. But for purposes of the bail analysis, and also kind of as a preview of maybe what we can expect at a trial, as prosecutors explain in this bail letter to Judge Caproni, which is again what we're going to be focusing on, this case, according to them, is much more broad. Quote, evidence from the government's investigation goes well beyond the conduct charged and shows that the Alexander brothers have, together and alone, repeatedly and violently raped and sexually assaulted dozens of victims dating back for nearly 20 years. To date, law enforcement agents have interviewed over 40 women who reported being forcibly raped or sexually assaulted by at least one of the Alexander brothers. The rapes and sexual assaults described by victims were committed between approximately 2002 or 2003 and 2021. In the victims' accounts to date, each defendant has separately been accused of forcible rape by at least 10 women. And by the way, Oren and Alon, who are twins, they also face state sexual battery charges out in Miami too. Now, this is in connection with 3 separate alleged incidents. And Oren faces charges in all 3. Alon faces charges in 1. By the way, what do sidebar stories like this prove? That the world is just incredibly scary and unpredictable. And honestly, when you think about that, one of the scariest and most unpredictable things in life can be getting injured, right? What are your rights? What do you do? Well, that is why having a great lawyer matters. And that is where Morgan & Morgan, the exclusive personal injury law firm of Law&Crime, comes in. So they're a firm with over 1,000 attorneys, and that is because they win a lot. Because in the past few months, Morgan & Morgan has secured a $29 million verdict for a bicyclist in Philadelphia, a $2.7 million verdict for a car accident victim in Florida, not to mention $5.6 million for a car crash victim in Georgia after insurance offered that client $0. Even if you think your case isn't worth millions, millions. Why not start a claim and fight for what you deserve? And Morgan & Morgan makes it so simple because you can start a claim from your phone in just 8 clicks. So if you're injured, you can easily start a claim at forthepeople.com/LC-SIDEBAR. But going back to the federal case, that's going to be our focus. This was really interesting because prosecutors explain in the letter that since the indictment, federal authorities have allegedly found more evidence against the brothers. Quote, the government has adduced even more evidence of the defendant's criminal acts. On or about December 11th, 2024, law enforcement agents executed a warrant to search an apartment in New York City leased by Tal Alexander. During the search, law enforcement agents seized numerous photos and videos depicting at least Oren, Alon, and several third parties recording or photographing themselves with women in states of intoxication and undress. In multiple videos, the women appear initially unaware that they were being recorded and became upset and attempted to hide or flee from the camera after realizing they were being filmed. In one video, the camera peeked over a bathroom stall where a woman and a man, who is not one of the defendants, are engaging in intercourse. When the woman looked up and saw the camera, she hastily began to get up, saying no and stating in sum and substance that she does not want all of friends. Multiple other videos found in Tal Alexander's apartment depict Alon, Oren, and other men engaged in sexual contact with women who were visibly under the influence of alcohol or other substances. In some instances, at least one defendant and another man physically manipulated the women's bodies in order to have sex with them, while the women did not actively participate in the sexual activity or turned away. In combination with the facts set forth in the detention letter, this evidence underscores the depraved nature of the defendant's conduct and the immense danger they present. So it's one thing to have witness testimony. It is entirely another thing to have video evidence. Now, I imagine defense attorneys here will work hard to have this evidence excluded from trial, perhaps suggesting it is prejudicial, perhaps suggesting that it's not really evidence of sex trafficking per se, that maybe it more addresses state sexual assault charges, not federal sex trafficking crimes. Actually, keep that in mind for a minute. We're going to address that in a little bit. But they may also argue, look, these videos shouldn't come into evidence, perhaps suggesting it was obtained by the government illegally. And we'll see those pretrial battles come. But on its face, yeah, that's not great for defense attorneys, those videos or those alleged videos. And right now, prosecutors say that that evidence is important for the bail analysis right now. Forget about its influence at an upcoming trial. That evidence is important for the bail analysis because here's the history regarding bail in this case. So the defendants were arrested in Florida on December 11th. Tal was ordered detained by a magistrate judge deemed to be a flight risk. The court weighed the evidence, the significance of the charges, and they all warranted pretrial detention. Another judge ordered Alon to be detained after a 2-day hearing, again, flight risk. And as for Oren, this month he waived his right to a removal hearing. This is about how to get him in front of a judge in the Southern District of New York where this federal prosecution is occurring. So he didn't fight to be extradited to New York from Florida. And also, apparently, Oren agreed to detention. But apparently he wanted to revisit that issue once he was in front of the Southern District of New York judge. And in fact, he submitted a letter last week to the judge overseeing this case in New York, Judge Caproni. And in this letter, he is opposing pretrial detention. I'll break it down for you real quick. His lawyers argued first that this case is legally faulty, that this seeks to convert years old and recently alleged claims of social context sexual misconduct into a commercial sex act for purposes of sex trafficking. But Oren makes the argument that the government didn't allege how he benefited financially from this or received something of value. He says that these allegations are more the jurisdiction of state sex crimes charges. Again, like I said before, that this isn't sex trafficking per se. Oren's defense counsel writes, the government's theory of the case is that if someone schedules a date, pays for that date's Uber ride from New Jersey to New York, and any non-consensual sex subsequently occurs, that is sex trafficking. Oren argues that's not sex trafficking. It doesn't work like that. He also fights against the conspiracy part of count 1 in the sex trafficking conspiracy charge, in that he says there was no agreement to break the law. At a prior hearing, he says the government alleged that the brothers had an explicit agreement to orgy, but that is not an agreement to do something unlawful. Now, these are interesting arguments, for sure, interesting defenses. Then they may work when it comes to a motion to dismiss the charges, or maybe even at a trial. It might be a good defense. I will say, though, I am not sure it is really an issue in a bail analysis. We're going to get more into that in a minute, but I don't know if it really applies right now. Now, more specifically, he addresses issues surrounding pretrial detention, because Oren argues that this case will require a lot of discovery, and if he and his brothers are behind bars, that is going to make it very difficult to prepare for their defense. We actually saw a similar argument in the Sean Combs case, but it didn't work there. It wasn't effective. There, the court and prosecutors made accommodations for Combs to review everything on a laptop in jail and to speak with his legal team. Oren also explains that just because he's charged with sex trafficking doesn't mean he shouldn't be released. Look at the Mike Jeffries case. We've talked about that before. Former CEO of Abercrombie & Fitch, who was hit with federal sex trafficking charges in New York. He was granted pretrial release on a $10 million bond. And again, Oren says he's charged with sex trafficking. Why can't we be released? Now, amongst the other arguments that are made in this letter, Oren also says he has no criminal history. He has strong ties to the Miami community, meaning he isn't a flight risk. And he says if he ran, his life and his family's life, including his children's life, would be permanently ruined. Now, to be clear about something, the Alexander brothers have all denied any sort of wrongdoing. In fact, attorney Howard Shrebnick spoke to WPLG after a hearing on Friday, calling the accusations baseless, saying not one of the accusers has testified before the grand jury, not one of the accusers has been subject to cross-examination, not one of the accusers has been under oath before a federal judge to point fingers at the defendants to say that they have done anything wrong. Now, with all that in mind, now I want to get into the government's letter that opposes the applications for bail made by Alon, Oren, and Tal. In other words, the government is asking Judge Caproni to affirm the denial of bail for Tal and Alon and to deny Oren's motion for bail. So let's talk the law here. So bail can be denied for a criminal defendant if there is a finding of risk of flight by preponderance of the evidence. That is a lower standard. That is much lower than, let's say, proof beyond a reasonable doubt. It's more likely than not is what we're talking about. More likely than not that something is true. Bail can also be denied based on the dangerousness of the defendant, and that actually has to be proven by clear and convincing evidence. That is a middle ground standard. That is a higher standard than preponderance of the evidence, and it is lower than proof beyond a reasonable doubt. It's a middle standard. It's saying it's highly probable that the contentions are true. Now, there are 4 factors to consider in a bail analysis. There is nature and circumstances of the charges, the amount and strength of the evidence against the defendant so far, the history and characteristics of the defendant, and does the defendant pose a danger to those on the outside if released? Now, there is a special caveat here because we actually saw this in the Sean Combs criminal case, but when you are dealing with a sex trafficking charge, again like the Alexander brothers, again like Sean Combs, there is a presumption of detention. It is a presumption that can be rebutted, but it is a presumption of detention. And it means that no set of conditions would be sufficient to assure the defendant doesn't flee or assure the safety to the community. So here the feds say the brothers are a flight risk and they are a danger to the community. Now we want to get into the why. So let's start with the dangerousness factor. The government repeats some of the core allegations in this case, where they say for more than a decade, the defendants worked together in a sex trafficking conspiracy that used force, fraud, and coercion to rape and sexually assault numerous victims. The defendant's danger has been demonstrated repeatedly and goes well beyond the charged offense conduct. The Alexander brothers' serial sexual violence began far earlier than the period of the charged conspiracy. The government's evidence shows that they have been raping girls and women alone together and with other men over a period of nearly 20 years. The government has interviewed more than 40 of those victims and expects the number to continue to grow as the investigation continues. The Alexander brothers drugged victims, rendering them incapable of either consenting or resisting. Then, when the victims were physically compromised or incapacitated, the defendants held them down and forcibly raped them. Some victims said no or stop. Others screamed. But the defendants ignored their victims' distress. Multiple women described being terrified that the Alexander brothers were going to hurt or even kill them. These victims' only goal in that moment became to survive. Multiple victims who were drugged required medical assistance in the hospital after their encounters with the Alexander brothers. In short, the defendants' conduct was inherently dangerous, involved numerous victims, and makes clear that the safety of others and of the community cannot possibly be ensured without the defendants' detention. Now, a couple of things here. Not all of those allegations will come into this criminal trial. But, as I mentioned, there is a lower standard when we talk about a bail analysis, so the government can allege more. They don't have to prove necessarily everything beyond a reasonable doubt in order to get detention. There's a lot more flexibility and leeway with what they can present now for a bail detention analysis versus what they have to present at a trial. Just keep that in mind. Now, from there, prosecutors address a specific argument or defense from the brothers, where it's, hey, government, you're saying there's a clear danger here, but there's only 2 counts of sex trafficking in this indictment, one with respect to victim 1 and the other with respect to victim 2. Well, prosecutors say in response, that in no way suggests that these brothers didn't also engage in a much broader pattern of sexual violence. Again, going back to the idea of they have a large leeway with what to argue in a bail analysis. And then the prosecutors say this, and this kind of gives us a preview of what to expect at a trial. They say that they expect not just the victims in the standalone counts to testify, like victim 1 or victim 2, but many, many more people. And they say as a point of law that they expect those witnesses to testify not only about the overall widespread, broad sex trafficking conspiracy that makes up count 1, but that these witnesses will also testify pursuant to Rule 404B and 413. So what is that? So 404B is about evidence of other crimes or acts or wrongs of a defendant that can come into evidence at trial. Now, it's not to show, oh, well, they did this, then that must mean they're guilty of the crimes that they're charged with here in this case. No, that's not proper. That's not allowed. But that evidence can come in to show a plan, to show a motive, to show maybe a pattern. So this is a pattern and a plan of sexual violence. 413 is more specific and says in sexual assault cases at a federal level, other evidence of sexual assault can maybe come in as well. So you're kind of getting a preview of what a potential trial could look like and who may be called at the Alexander brothers federal trial. Now from there, prosecutors say that all of this testimony in this case will be backed up by witnesses, electronic evidence, physical evidence, and documentary evidence. So what you're seeing from the federal prosecutors is that there is a strong sense of confidence in this case. We always say the feds don't bring a case unless they're fully ready to win. That's why they have such a high conviction rate, particularly in the Southern District of New York. And I will also say statements like this show that they are quite far into their review and investigation into this case too, which, by the way, they should be. Obviously, they brought the charges. But from there, let's talk about what the prosecution says next. The prosecution also says that the victims' accounts corroborate one another. And that's important because when you have what seems to be the argument here, independent witnesses who come forward and they say the same kind of thing, that shows a pattern. That shows that they're credible. It's not like they all came together and came up with stories. No, that's very different from what it seems prosecutors are saying here. Now, prosecutors are also arguing here that for the dangerousness factor in a bail analysis, we are talking decades of alleged violent conduct. So not just sexual assaults amounting to sex trafficking, but what they say is, quote, a disregard for humanity. And here's an interesting point in the letter, too. They write, the defendant's arguments that they are not dangers to the community because the charged conspiracy ends in 2021 or because the rapes described by the victims to date occurred earlier is of little mitigating value when considering the scope and duration of the defendant's pattern of violence. The evidence in this case shows that the charged sex trafficking conspiracy continued at least until 2021. Second, it is similarly unavailing to claim that the present lack of more recent assaults indicates that the conduct has stopped. There is no evidence demonstrating that the defendants learned the error of their ways. The fact that video versions of trophies of the defendant's criminal conduct were found in Tal Alexander's residence as recently as last month also suggests that the defendants have not closed the door on their criminal conduct. Finally, a nearly 20-year unbroken pattern of violence that targeted scores of women that the defendants met in both planned and chance encounters is in and of itself clear and convincing evidence of the continued danger the defendants posed to the community. That the Alexander brothers' sexual violence persisted despite several victims' attempts to report their assaults to others demonstrates that the Alexander brothers cannot be trusted to stop their violent assaults, even in the face of criminal charges. The evidence demonstrates that for decades, the Alexander brothers have acted with apparent impunity, forcibly raping women whenever they wanted to do so. In short, the risk of the defendants' continued sexual violence and to facilitating the sexual violence of each other cannot reasonably be prevented through bail conditions. And prosecutors highlight that so much of this alleged sexual violence happened in their apartments, in their homes, in hotel rooms, in private settings, behind closed doors. So that was all the dangerousness factor. Now let's move on to the risk of flight factor. And when we talk risk of flight, one of the major issues is the seriousness of these crimes and the serious penalties. We are talking about a mandatory minimum sentence of 15 years in prison for counts 2 and 3, and up to life in prison on all the counts. In other words, there is an incentive to run away, to flee. And prosecutors say the brothers have an incentive to flee because of the reputational damage that a trial would have nonetheless, even if they're found not guilty. Writing how the brothers carefully curated their public image and reputation in the real estate and security industries, and that a public prosecution and trial will drastically affect that they will flee. They will not want to subject themselves to this. The government writes, for example, the government is in possession of multiple video recordings created by Oren Alexander depicting Oren and Alon engaging in sexual activity with at least one identified victim. As described above, additional videos found stored on hard drives show the defendants and other men engaging in group sexual contact with a number of women, including numerous women who are visibly impaired. Put simply, the defendants have every incentive to flee to avoid prosecution and a public trial, putting their criminal exploits on display. And the government also highlights how the brothers have strong family ties to the nation of Israel, how they've traveled frequently there. There's a risk that they can just go there, reestablish their lives, and have no issue. And that's interesting because we always say, oh, someone can flee, but really, where would they go? Are they really a flight risk? Could they really start a new life somewhere else? Well, here, prosecutors are saying that the brothers could easily set up shop in Israel and there would be no problem. And then, maybe not surprisingly, when it comes to a risk of flight analysis, the prosecutors highlight the brothers' vast financial resources, their wealth. And I mean, they say Alon proposed that the Alexander family can post bond, quote, in any dollar amount. So again, when we talk about that, their ability to just run away, that's important. And the prosecutors highlight that the brothers can travel by private planes, by boats, and that makes it much harder for law enforcement to track the brothers' movements. And the government argues that the defendants' proposed bail package, their answer to all of the government's concerns, they say it's insufficient. So what's the bail package? Well, it has 3 main components I want to talk about. One is a bond of $115 million, or in any dollar amount. 2, private security to monitor the brothers' movements inside of a luxury condo. And 3, the execution of preemptive waivers of extradition, basically saying if you should end up in another state or country, you're giving up your right to an extradition hearing. Essentially, you're giving up your right to fight extradition back to New York. Basically, the brothers are saying, don't worry, government, we'll come back. No worries. Now, why is all of this insufficient in the government's view? Well, first of all, let's start with the money amount. So the government explains that the defendants proposed securing that incredibly high bond amount with various properties. But the government argues, even if that's the case, the brothers would still have vast resources if they flee the country. For example, while Alon listed out the financial information that he has regarding his own liquid assets, what about those of his family? Also, we're talking a family that reportedly has $10 million worth of property outside of the U.S. In other words, the government's saying these brothers could risk losing all of their properties and assets if they flee because they'll still have enough on the other end. If they could just flee to another country, relocate, and start business up again. Then there's the issue with the private security condition in the bail package. So a few things here. First, the government says there's a conflict of interest here when a defendant is paying for his own jailers. That was the same argument that was raised by prosecutors in the Combs federal criminal case as well. How can we trust the private security that is on the defendant's payroll? Also, the government says that this private security team, they don't have the same kind of resources to stop or restrain a defendant when you compare the guards of a jail or a detention center. Those resources are much more limited. It also doesn't help that the brothers propose being on house arrest in Miami, which is 1,200 miles away from the New York federal court. In other words, that creates a greater risk when transporting them, places an undue burden on the courts and law enforcement to ensure that the defendants don't flee. But the government also made another argument that was brought up in the Combs case too. And this is the two-tiered system of justice argument. In other words, it's not right that defendants of lesser means who can't afford private security are detained pre-trial while those who can't afford it are released, it's leveraging their wealth for special treatment. Now remember what the counter-argument to this was. This is something that was argued by Sean Combs. Ultimately didn't work, by the way, to get him bail, but he had different circumstances there. But the argument is, well, we are only proposing such an expensive bail package and private security because the government has raised issues about our wealth and our resources. We have to present something this extreme to address the specific concerns the government has about us as wealthy individuals. The government can't use our wealth as a sword and a shield. So we'll see if that argument is presented and might be successful. And finally, when it came to that last condition of the bail package, the Alexander brothers' proposal to execute those waivers of extradition that I mentioned, the government says this is an empty gesture. It's an empty promise because we don't even know if those would be legally enforceable. So the government concludes and says, quote, as set forth above, Alon, Oren, and Tal Alexander pose an ongoing and significant danger to the community and present a serious risk of flight. The government respectfully submits that the defendants cannot meet their burden of overcoming the statutory presumption in favor of detention. There are no conditions of bail that would assure the appearance and compliance of the defendants or the safety of others. Accordingly, the defendants' applications should be denied. Now, before we finish up, I got to talk to you about this one little mix-up that apparently happened last week when it came to bail. So it was reported that Oren had a scheduled bail hearing in Miami federal court, but was almost accidentally flown by the U.S. Marshal Service to New York. Yeah, according to reporting from the Union Bulletin, a U.S. Marshal spokesperson said that Oren was in a car on his way to the Miami International Airport when they realized their mistake. That spokesperson said that Oren was never on a plane and never left the state. But look, good thing they caught this mistake. Could have created a larger issue. But let's see where this Alexander case goes next. We will continue to follow it for you here on Sidebar. But that is all we have for you right now, everybody. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.